Very well. Good morning and welcome, everybody. It's my great pleasure to see you and welcome you at today's webinar, European Family Law Trends, that is held with support of Ferenc Mádl Institute of Comparative Law. It is my pleasure to welcome everybody and mainly speakers today. I guess that all of you have seen the program, so you already know who will be speaking. Mainly, all of the speakers are doctoral students at the Masaryk University Faculty of Law. And I guess that without further delay, we can start with the first presentation that will be delivered by our colleague Lucie Zatloukalová on a topic of divorce and its simplification within the context of Czech Republic. So, Lucie, the floor is yours.
Okay, thank you. Hello to everybody. I will just share my presentation, so give me please 1 minute. Okay, can you see the presentation, please?
Yeah.
Great. Okay, so I will start with some description of a current law in Czech Republic, which parents or divorcing parents have to know and go through when they divorce with the minor children. So the current law counts with the obligatory court judgment over children, and they cannot divorce without the judgment of the court. So it bounds them to go through proceedings to find an attorney, usually, and so on. So this is the, and this can be a problem, and also in some things it can be good. I will go through it later. This law applies in a case of conflict and also in a case of agreement. So if the parents can agree and the divorce is agreed divorce, nevertheless they have to go through custody proceeding. So the custody proceeding can be started ex officio, and also to the apply of one of the parents. It can, in a practice, it causes some delays of divorce, because the custody proceedings can take months or the years. And also the custody proceedings as a first proceeding in a divorce can be the first battlefield for the parents in conflict, where they can have the conflict before the court. So it's the first proceeding, and it's about the children, so it can be a problem. The biggest problem, in my view, is the delays of the divorce. So if two people in Czech Republic can want to divorce, they have to usually wait more than 1 year if they have minor children. So we have amendment to the Civil Code, which should change this practice and the law. And now I will name some aims of the amendment. Why is it proposed, and what should it bring? It's amendment number 1214 to the Civil Code, and it should simplify divorces with minor children. It stands on the thought that the responsibility for children is primary on parents, not on state. This amendment should support parents and their responsibility for their children, and bring less state ingerence to the privacy things. So its aim is to respect privacy, family life, and freedom of the parents, where they don't need to have a state ingerence. Also, this amendment should support agreements between parents and motivate them to bring the agreement to the court. Also, not the primary aim, but also one of the aims is less the burden, which is put it now on a custody court, because there is a lot of cases and the custody courts have a lot of delays, and then it brings many problems, and can bring a conflict to the situation where the conflict wasn't before. So this is the aims of the amendment. How should the new law and new proceeding look? I will now try to describe. The main thing or the main change is that the court decision over children should not be obligatory to divorce. So to parents who want to divorce doesn't need to have a court proceeding and the court decision over the custody of the child or the maintenance. Obligatory is just, or would be just, a written agreement with the verified signatures or written at a notary. So it brings the responsibility back to parents for the custody of the child, and not to a state to decide what is the best for their children. It should or it will be still possible to start court proceedings in a case of conflict, or in a case where the interest of the child can be in some danger, or so on. So the state can still start ex officio the court. This stands on the thought that the parents know what is the best for their children, what is the best interest, and what can bring some peace, and what can work for them. So this is the essence of the amendment. This is how should the new law look. There are also some arguments against the amendment, which are brought by the Czech Bar Association or the Union of Family Law Lawyers, and they say that the child protection and protection of the best interest of the child in the conflict of parents can be unsecured in this case, because nobody will check if the agreement of parents is okay for the children, if it's not too much, if the children doesn't move from one corner of the country to another, or if the maintenance is okay, and so on. So the state cannot secure these things. I think that this argument is reasonable, and but I think the more important is give a trust to the parents that they can secure what is the best for their children. Also, not everybody is in a marriage. Not everybody who splits a relationship is with the children is in a marriage. So there is so many parents which are splitted, and the custody or the maintenance is without any court ingerence. So I think that the security of the child, or the interest of the child, shouldn't be the main argument why not to bring this new law. Also, one of the arguments is that simplifying divorces should not be a purpose, because we want to stable marriages and stable social system and so on. But this also doesn't respect the freedom of the people who wants to split their marriage or wants to divorce, and usually there is no good outcome of giving more problems or bringing the more problems to them to solve before they want to divorce. So if this is also the right of two people to decide to divorce. So we should probably the state shouldn't ingerence in this decision too much. So this is the arguments against which we can hear to this amendment. And in current situation, the amendment was proposed in a legislative proceedings, in a shortened proceedings, just one reading, and it should be accepted. And it looked like it will be. It should have been in a new year now, but we have elections in Czech Republic, so all these legislative proceedings are stopped or more slow than they should have been. So it was the deciding over this amendment was interrupted, and now we are waiting what outcome will be, but it's not decided yet. In the end of my presentation, I would mention that the same law or the similar law is in, for example, Germany, Netherlands, or Switzerland, and some other countries in Europe. So it can be said that this is some standard of divorce law, that the agreement of two parents is preferred than the ingerence of a state authority to their private matters. So now we will wait what outcome will be from deciding of our legislatives. Also, in the Czech Republic, there was some thoughts and some moves that the divorce of a marriage should be made at a notary and not at the court, but it was not realized. So, if the both changes would be realized, then the people wouldn't have to go to court if they want to divorce, because the children could be solved by a written agreement with the verified signatures, and the divorce would be at a notary. So this would be quite a big simplification of divorces. But the second part, the divorces at notary, is not now in any amendment, or is not now on a possible outcome of this amendment I'm talking about. This is just about the custody proceedings and about the children. So my opinion to this amendment is that it would be good in practice. It would bring, I think it would bring maybe a more calm custody decidings between parents, because they know that they don't need to go to court and don't need to have any evidence against the other and so on. So I would welcome this change in law in Czech Republic, but we don't know now. So this is everything I wanted to tell during the presentation, and thank you very much. And if you have any questions, or if you have some interesting information about your country. If here is somebody from abroad, I would welcome the information about how it works abroad. So thank you.
Thank you very much, Lucia. I guess that we can have a discussion immediately after each presentation, but just to you to be aware of the possibility to discuss. Also, at the very end of the webinar, we have a slot of probably 10 or 20 minutes for discussion at the very end. So it is possible to raise any questions or comments right now, and there will be possibility at the very end as well. So, in case that anybody would like to comment Lucy's presentation, please raise your electronic hand now or later on. And if not, I guess we can move on. And it's my pleasure to introduce to you our colleague Jana Markova, and she will present some remarks on the influence of COVID-19 on family law from her perspective. So, Jana, it's yours.
Good morning, everybody. Thank you. I will share you my presentation. Give me a minute. Can you see it or not?
Not yet.
Okay. Now?
I still don't see anything. Oh, yeah, now it's starting. Yeah, it works.
Thank you very much. That's the problem, mainly the technical issue. So, I would like to speak about the impact of the COVID-19 pandemic on family law. I know that it's not the trends in European family law, but in my view, I think that there are some issue that pandemics bring on a family law. So that's the main, in my view, it's important to speak about it. So, firstly, here you can see, I hope that you can see, I'm so sorry that it's only in a Czech language because it's from a Czech view, but I can translate if you want to know it. Here you can see the graph that showed the most common problem associated with COVID. On the first place is financial problems. Then we can also see that some families lost of housing or have some physical or mental exhaustion or issue, and so on. So it's normal then when a family spend more time together, they have more problems. Yeah, I can see it also in our family, mainly in 2020, when we're locked down and we spent time together. There are more and more issues, and it's also have a negative impact on families at all. So it's normally that families have problems, but there are some vulnerability groups. For example, single parents, because they can have more financial problems. For example, when they lost a job or stay at home, they have lower income than normally. Or also, as I spoke, I'm so sorry. As I spoke with some of my colleagues when I spoke with my colleagues, they do family law. They told me that they have more and more domestic violence or adultery, and of course divorces. In my view, the most vulnerable group is single parents. I would like to speak, or next, I would like to tell my second point, and my second point is that there are some problems closely linked to emergency measures. For example, when the families are divorced and they have to transfer of a child while movement of person is restricted. For example, in spring 2021, we have district closures. So when we want to cross border of our district, we have to show some paper, and we have to transfer a child. So prohibiting all persons from leaving the territory of the district in whose territory they have some exemptions. There were necessary travel to ensure the necessary needs of relatives and relative of needs for another person, and also the child care and the exercise of the right to maintain person contact between parents and minors, including the necessary escort of a minor of the journey for the purpose of personal contact with parents, ensuring the care of animals, waste disposal, and so on. So some parents don't want to transfer a child, and they want to stay with a child or children just they own, but they were exemption, so that there was no reason to stay just with one parent. I also would like to mention this book. It's a German book from Nomos. They have a closure of the lender in Germany. They have something very similar right now. Because the pandemic situation is not so good, and they also have the exemption in the emergency measures, because in my view it's still very important to have the relationship with both parents. I have an example from my family, and it's not a good example. When children just stay with my sister, and they don't meet the father, and we can see that there are more and more problems to make their relationship as good as was before the pandemic. So it's really important to have these exemptions and stay with a normal contact. Of course, it can be another reason when is quarantine or isolation of one of the parents, or quarantine of isolation of the child. So let's move. uh, in my view, it's depending if children or parents are ill or have quarantine or isolation. Uh, in my view, it's depending which parent have quarantine or isolation. It's better from the health view to stay with the parents we are in the moment when he or she is in infection, but also there are some exemptions. So when we are at the same home, it's better to stay and be more flexible with another parents than in normal case. So there are also some most common dispute in the Czech Republic. The first, failure to pass on a child with a risk of infection. So it's okay from my view, but some parents just say they are a risk of infection because my ex-husband or ex-wife have more social contact, met more people in work, and so on. In my view, it's good to make an agreement, or just some agreement. Please stop your social contact. Please do more to protect our child. So it's not the best thing. Just say no. I will stay with my child because you are not as good as me in this point. As we talk in as we talk. There are also just problem with transfer of a child, and another problem is with alimony, because they were calculated on the basis of a previous income. For example, in some some jobs when someone works as a waiter or as a in hotels and so on. They have reduction in incomes, and they don't have as much money as they have before. So there are still some issues that can help with law, but we can make an agreement, and it's also depending on parents and their relationships. And at all, they were more they were increased submission of care change proposals. It's also one of the main problems. So I would like to just briefly talk to my recommendation. In my view, it's mostly uh, I'm so sorry. In my view, parents have to speak to each other and make some agreement. They have to be flexible, more flexibility, and they have to speak about their needs. In my view, it's the best solution to find a flexible solution for both, because it's not easy situation for anyone. And sometimes it can help to go to mediation or start a mediation. It can be also the new way to make the relationships in family better. So I just want to show you what is the main problems in my view, and maybe some resolutions or recommendation what we can do to make it better. I also know that there is not a problem between a family, I mean mother, father, and child, but also with a grandparents, when sometimes they can see their grandchildren during the whole pandemic. So it's great to be careful, but it's also there are also needs to don't forget about the relationship in families and the impact of quarantine or isolation to the children or to the grandparents and parents. So we have to stay or to make the relationship or to stay together in a contact, maybe also in person or also online, but we have to deal with this situation. So that's all from me. Thank you for your attention. And if you have any question, just don't hesitate to ask me.
Thank you, Jana. So I as well ask the attendance. Yeah, Lucy?
Yeah, I don't have a question. I just wanted to say that in our practice in attorney office, we met almost every problem that was named here, and the main problem was the not giving the children to another parent during the quarantine. And there was a lot of court decision executions and so on. And when I dealt with it, I was calling to the regional hygiene and they told me that it's possible to report 2 places of residence in case of quarantine and so on. So there was no reason to not give a child to the second parent. Just one if the children was ill and it was not possible to travel and to give the child to another parent. And also the maintenance, there is a problem that if the courts decides after the year 2020, usually the maintenance is quite low, and now it's not still actual now, so we have to sometimes to start a new court proceeding just about the maintenance, for example, because the parents has raised their income now. So yeah, it was very actual, and I also met these problems in a practice.
Thank you for this point. I'm so happy, I'm not happy that you made it with this problem, but thank you for this point.
Yeah, well, I can agree definitely from my experience and my perspective as well. The parents very oftenly used quarantine or lockdown in general as an excuse why not to hand the parents to the other, to children to the other parent. Yeah. Okay, so if there are no other comments or questions, we can move on to the third presentation, and our colleague Karl Lach will be speaking about the rights of vulnerable adults in respect of family life from perspective of European Court of Human Rights. So again, the floor is yours.
Hello, everyone. Thank you. I have to admit that I'm a little bit nervous, so please forgive my shaky voice. I will try to share with you my presentation. So just give me a second, please. I already see some technical problems. My computer doesn't know this app, so I have to.
So, well, there is a possibility that you will send to me your presentation via email, and I can start it, and well, it is possible.
It says that I have to close the application and reopen it again. I think that this might be quicker.
Your choice. You can try that. Sure.
That's the problem if you have MacBook. I know it also. So now I use another computer to these actions.
Welcome back.
Thank you. Hopefully it will work this time. I'm really sorry for this delay.
No problem, I guess.
It's quite slow. Okay. Oh, please not again.
Well, we can see your desktop, so.
Yeah. Okay. So you can see the presentation now.
Yeah.
Yes.
Yeah, cool. Okay, so hello again. What will be the outline? My name is Karel. I work in the non-governmental organization called League of Human Rights, and apart from that, I'm also a doctoral student here at Masaryk University. First, we will have a look at the term of vulnerable adult. What is it? What can we imagine under this term? Then we will talk about a little bit about right to family life in general, and then I will move to more specific topics, which are right to marry and the withdrawal of parental responsibility, which I will talk about with the consideration of decision-making practice of the European Court of Human Rights. Okay, so who is a vulnerable adult? The concept of vulnerability has no universal definition. Maybe there's even a question if it's possible to create a universal definition of this term. I'm not so sure about it yet, but maybe I will in the future. However, there are almost no well, in the older international instruments, like all kinds of human rights treaties, there are no mentions of vulnerability. There are some mentions in the newer treaties, in the newer documents, and there are even fewer definitions. But the important thing is that every definition in this kind of instruments are specific to the field of the instrument. So, for example, the Convention on the International Recovery of Child Support and Other Forms of Family Maintenance has a definition of a vulnerable person, but it's connected to the topic of the convention. When we have a look at the European Court of Human Rights and its convention, there is the Article 14, which prohibits discrimination against also all kinds of aspects of vulnerability, which can be also sex, age, but disability as well, which is not mentioned explicitly in the convention, but it's mentioned in the jurisprudence. So the European Court of Human Rights applies the concept of vulnerability via this discrimination clause. And it says in the decision-making process that the state parties and its national authorities have to take vulnerability into consideration, as well as the European Court of Human Rights does. My focus will be in accordance with Convention on the Rights of Persons with Disabilities, because for me it's not easy, but it's obvious to imagine the aspect of vulnerability with the persons with disabilities. And there are some interesting rulings from the European Court of Human Rights, and the rulings are also in accordance, or should be in accordance, with Convention on the Rights of Persons with Disabilities. The European Court of Human Rights should not go against the Convention on the Rights of Persons with Disabilities, or should not decide against the rights guaranteed by the Convention on the Rights of Persons with Disabilities. Okay, so we have the vulnerability covered. Let's move to adulthood. I chose to say I chose to say something about the adulthood because it's also very important. The Convention on the Rights of the Child says that every person under the age of 18 is a child. But in Czech Republic, we turn to adulthood when we are 18, yes, but also when we get married before 18, but we have to be at least 16, plus we have to have a court approval. And also there is the third possibility, which is declaration of autonomy. So if these conditions are met, then we can say that there is a vulnerable adult. And let's move on to right to family life. I will talk about the people with disabilities. I said that apart from the European Convention on Human Rights and the Article 14, the discrimination clause, there is the Convention on the Rights of Persons with Disabilities, which is very important in order to understand the position of the people with disabilities. The important article is Article number 1, which talks about the purpose of the CRPD, which is the abbreviation of the Convention of the Rights of Persons with Disabilities, and the purpose is to protect these people, these persons, and to help them exercise all of their rights that are guaranteed by the convention, which are basically all of the rights that we have. There are just some measures to ensure that even these vulnerable people may exercise that. Um, then there is Article 12, which says that every person with disability, and by the disability, the convention means every kind of disability, which is physical, mental, every kind. So the Article 12 says that every person with disability has a legal personality and is on the same grounds that we have. So it should be equal. It's not like that in Czech Republic because there can be a limitation of legal capacity. But there's the question if our law is in accordance with the CRPD or not. But I will not talk about this now. It's just something to think about. Then there is also Article 22, which says that the state cannot interfere in the rights of persons with disability to private life and family life, which is very important. And the other important article is Article 23, which says that the state has to take positive measures, positive steps to make sure that persons with disability may exercise their right to private and family life in full range as we do. So it means that they should be able to get married, they should be able to choose if they want to found a family, how many children they want to have, everything. And the state should make sure that it's possible. Again, the question is it really real, or is it just an ideal to move on? Because our law is not 100% there. There are some limitations. Okay, and now we will move more specifically to the right to marry. I chose four decisions overall, which are uh, quite interesting because they show that the European Court of Human Rights is not very consistent in its ruling. Here, in the case of Delacour versus France from 2018, there was an elderly man who unfortunately died in 2016, who was not allowed to marry a longtime friend of his. And the court said that there was no violation of Article 12 of the Convention, which guarantees the right to marry. Uh, this man was under partial guardianship because he had light cognitive disorder, and because of that, he was not able to manage his property or finances, and so he needed consent from the guardian in order to get married. He did not get the consent, obviously, but there was a medical report that said that he was indeed able to consent to marriage. The European Court of Human Rights said that there are some limitations to the right to marry, and they should not, the limitations should not interfere with the essence of the right to get married, or it should not be arbitrary or disproportionate. Um, at this point, the court said that there was no violation of Article 12. So the case and its limitations were proportionate, were not arbitrary, and did not interfere with its essence, according to the court. I will leave up to you if the court is right or no. But there are experts that says that the court with this decision removed all of the persons with disabilities and persons lacking legal capacity from Article 12 without a substantive test, because there was no substantive test done in this decision making. And also, what is very interesting is that the court did not mention CRPD at all, and especially the Article 12 and 23. So there is, it's a very strange thing to see, because the European Court of Human Rights should take into consideration the CRPD and the rights guaranteed in that convention. Yes, so this is an interesting case. Another case is Mr. Lashin versus Russia from 2013. It was a man with schizophrenia because of that he was legally incapacitated in the year 2000. And he had a woman, and they wanted to get married in 2002. I'm sorry, I just have to. Yeah. So they wanted to get married in 2002, but the Russian authorities declined their notion to get married. It was because the Russian law prohibits legally incapacitated persons due to mental disability to get married. We have something similar here. I will not talk about it because we don't have that much time. But in 2002, when they wanted to get married, the men tried to be examined again by the impartial and independent experts in order to get his legal capacity restored. But it did not happen, and at that time he had a guardian, which was his father. And when that person with schizophrenia was hospitalized, they removed the guardian of being his father, and they appointed a new one, which was the hospital. And the hospital went against Mr. Lashin and made the court confirm that the deprivation of legal capacity is still effective, is still valid with this person. So the legal capacity, So the European Court of Human Rights said in this case that the legal capacity may be restored, but the states have margin of appreciation. So the state may have some kind of conditions. But the court also said that the measures that are very drastic and have a very severe effect on personal autonomy, as it had in this case, there should be stricter scrutiny, and measures must be fair and respectful according to the Article 8 of the Convention. This is very interesting because the court basically said that the Article 8 was violated because the relationship of Mr. Lashin's individual's capacity and his ability to enjoy his private life were in conflict, and that he should be examined when he wanted to be examined, and considering the legal capacity, and because of that he couldn't get married. So it was that. And the interesting thing is that it's the opposite saying as the Delacour versus France that I was talking about earlier, because here the court says that there should be stricter scrutiny when it's when the measure is more severe for the person, but here in Delacour he said that it was really okay because yeah, it was under the law and everything was okay. So I'm not sure if I am expressing myself clearly. Maybe you can ask later, but On one hand, the court says that there should be stricter scrutiny, but on the other hand, the court is not consistent with this saying and does not scrutinize the case every time. Another specific law is not the law, but the field is withdrawal of parental responsibility. And here is the case which is very, very important, and it's Kutzner versus Germany from 2002. And when I read this case, my mind was completely blown because it's really ridiculous. There was a mother and a father, and they both had learning difficulties. They lived in a farmhouse of the father's parents, and they had two daughters. And these two daughters had physical and then also mental disabilities. So because of that, they needed educational assistance and other measures and support from the state. Later on, there was the deprivation of the parental rights, and it was because social services uh, were not happy about cooperating with the parents, and the court says that the parents are not intellectual and emotional capable to bring up their child and children, and that also the children were late in their development. So there was this withdrawal of the parental rights. The thing is that the children were separated from each other, and each of them were put in a different foster parents. And the parents couldn't visit the children for 6 months. And then, when they applied to the court that they wanted to see their children, there was a ruling that said that they can visit them, but just for 1 hour a month, and then 2 hours per month. But with 8 strange people, they could meet their children with 8 people being present. Uh, why? I don't know. Uh, so the result of this decision of the European Court of Human Rights is that the measures that are taken in order to maybe um, to fulfill the legitimate aim, which could be to protect the children from harm, from physical harm, and for their development to be okay. There are these measures, but they have to be temporary and discontinued as soon as possible if it's reasonable, because the general aim with the deprivation of parental rights and separating children from their parents is to reunion the family, is to is for the children to get back to their parents, to their original family. And the court also said that the state have positive duty, and it's again uh, to take positive measures in order for the family to get reunited again. And the longer they stay separate, the stronger the duty is. And with that, always the state has to take into consideration the best interests of the children, which is also according to the Convention on the Rights of a Child. So because of that, the court said that the Article 8 was violated. And in the last case that I will talk about is Dmitry Ryabov versus Russia from 2013. And this is also very interesting because both of the parents of this child were suffering from schizophrenia. And the mother, dies after giving birth to a son in 2002. So there is just a father, and the son was immediately placed in his maternal grandparents' care, so the parents of the deceased mother. But the father was restricted access to the boy. He couldn't see the boy, and the condition in order to see his son was to have a consent of the son's guardian, which was his grandmother, the mother of the woman that died, and who was very hostile towards the father. So there was basically no contact. And the court says that there is no violation of Article 8. Again, I don't know. I don't know why, but the court said that I mean I'm laughing, but it's not very funny, obviously no. But yeah, the court said that that there was an interference with the Article 8, but it was um, it was in accordance with the law. The measures pursued legitimate aim, which, as I said, were to for the child to be healthy, to have good morals, to guarantee his rights, his freedoms, everything, and that it was really necessary in democratic society. Um, I'm personally I don't know if it's really necessary to have the guardian as his grandmother and to for her to give consent to his father in order to see his son just because he had schizophrenia, and the grandmother thought that he was dangerous for the boy. I don't know. I think that there could be some less severe measures taken in order for the father to get in contact with the son, or even there should be some measures, as I said earlier, to get the son reunited with his father, because he obviously really loved that boy. So, yeah, this is the inconsistency of the court ruling of the European Court of Human Rights. I hope that it was clear what I said. I hope it didn't take too much time. And if you have any further questions, I would try to answer them if I know them. Thank you.
Thank you very much. Any questions or comments right now? If no, okay, Joy, please.
Hello. I'm sorry to bother you, but I just wanted to thank you all for this amazing conversation. Unfortunately, I have a class just right now,
Sure,
so I have to go, but I wanted personally to thank you all. So thank you.
Okay, bye, Joy.
Goodbye.
Okay, so we can move on to the last presentation, and that's mine. Give me a second to start it. Okay, you should be seeing it right now. Can you see that, please? Great. Okay. So the main aim of my contribution today is to briefly comment a couple of interesting and important cases decided by the European Court of Human Rights during the last year. I will start with judgment on case X versus Poland, very recent one. And I will give you a short description of the facts at the very beginning. So, the applicant married another man. They had four children during their marriage. But later on, after approximately 13 years of marriage, the applicant, a woman, became involved in a relationship with another woman and started divorce procedure with her husband. Obviously, before and during the divorce procedure, also custody of the children was an issue, and Polish authorities, Polish courts awarded custody and parental rights to the father in the first set of proceeding, I would say. After the national judgment became final, the 3 of the 4 children were immediately moved to the father. I mean, willingly, they were older ones. But the last one, the younger one, son, remained with the mother. So second set of the procedure started then, leading to enforcement of the previous judgment. And the youngest boy was taken from the care of the mother and put into the care of the father, mainly based on the fact that the mother, lived in a stable relationship with another woman at that moment. So she applied to the European Court of Human Rights, and the court found violation of the Article 14 and Article 8 in that case, because found unlawful and against the convention the refusal to grant the applicant, I mean mother, full parental rights and custody over the youngest child, and it was really based solely on consideration regarding her sexual orientation. The court also sort of pointed out that obviously there are some advantages of the solution when all the children are in the care of the father, mainly that all the siblings will be living together. But the court also highlighted that the main purpose of the decision is to protect the best interest of the child. And in this respect, the National Court didn't take into account that there was very strong bond between mother and son proven. And compared to other older children, there was no proof that that child was not liking to live together with mother and her new partner. The older children weren't so happy about the fact that the mother was living with another woman, and they didn't like that woman. But as I said, this application was not so much about the older children, but about the youngest one. And moreover, the mother was the child's primary carer before the removal of the son before that. So that was also the fact the National Court didn't take into account from the perspective of the court, and therefore there was a violation, as a court said in that judgment. I can say, if you will study the judgment carefully, there is sort of a missed opportunity from my perspective, because the court didn't say that sexual orientation of the parent is per se on its own unlawful, and that it couldn't be taken into account at all. The court just weighted all the aspects of the case and didn't pursue that way, that possibility saying that it is unlawful and against the convention to discriminate on that ground of sexual orientation. If we can compare that to older judgments like Hoffman versus Austria, when, for example, religious belief were taken into account, speaking about religion, the court clearly said that no parent could be discriminated and no parents could be sort of have a restricted parental authority and rights just based on the religion. Compared to that, the court took a bit different approach in this case. But yet, we can call it sort of a win for an applicant, definitely, despite that. Okay, the second judgment I would like to draw your attention to is AM and others versus Russia. The main issue there was that the applicant was a trans woman who originally married another woman, and they had 2 children together. Later on, they divorced, and the applicant started her gender transition to a woman. At that moment, the children were 4 and 7 years old at the time. And at the request of the mother, I mean the wife of the applicant at the time, who thought that gender transition had caused irreparable harm to the mental health and morals of the children, national courts restricted parental rights and also access of the applicant to the children. Therefore, she, on her own behalf and also on behalf of her children, both of her children, complained to the court, a European Court of Human Rights. And the court found a violation of Article 8 and also Article 14 taken into conjunction with Article 8. But what's quite interesting in that case is that the court didn't like possibility or found the application inadmissible in respect of the children. So the court says that in cases arising out of the dispute between parents, only the parent who has a custody and parental rights is entrusted with safeguarding of child's interest, and only that parent could apply to the court. So in that specific case, just based on the fact that she was before sort of stripped of her rights to those children, she couldn't apply as their representative to the court. Such approach is taken by the court for a long time, but in this judgment there were concurring opinions by some of the judges who said that this approach should be changed because it doesn't make sense that the parent who is stripped unlawfully stripped of his or her rights couldn't apply to the court also as a representative of the children. The third of 5 judgments I would like to speak about is Fedotova and others versus Russia. This decision is sort of a bombshell for Russian authorities because mainly the applicants were applying to the court based on the fact that their relationship, same-sex relationship, wasn't formally recognized and acknowledged by Russian authorities, mainly because they didn't have any opportunity to form stable relationship and had it legally recognized, formally acknowledged in the form of registered partnership or any similar law institute. And the court, following its previous judgments like Oliari versus Italy, found a violation of Article 8. In comparison to a case Oliari and Italy, well, it has to be said that in Italy, there was at least by the law possibility to form a legally recognized relationship for same-sex couples. But in Russia, as probably all of us know, there was no such possibility in the time when the applicants, and still is no possibility, but also they didn't have such possibility in the moment when they applied to the court. And yet, despite this difference, the court said, well, you have positive obligation to recognize such relationship. And well, it is not a big surprise that Russia requested for a referral to Grand Chamber. So the judgment is not final yet, and we will see which approach would be taken later on by the Grand Chamber. Hopefully next year it will be definitely clear whether within the context of Council of Europe there is really a right to have legally recognized relationship when you are a same-sex couple, finally. The fourth judgment is also against Russia, Gruba and others versus Russia, and the main point here was discrimination based on gender. Basically, the male police officers asked for paternity leave and weren't allowed to take such after their children were born, just based on the fact that they are men. Because Russian law at the time restricted paternity leave for just a woman. And the court obviously and clearly stated that you have to differentiate between possibility to have leave immediately after the birth of the child. That is clearly intended for a mother, just to have all the health issues solved before coming back to work. That's normal that only women have such possibility, but you cannot discriminate men just based on their gender from the access to the paternity leave. Therefore, the court found violation in this case as well. And the last one is against Iceland. It is good example why sometimes is better to have the applicants anonymous, because to say the name of the applicant correctly would be probably impossible for me, but I'll try that. So it was the case Valdis Fjölnisdóttir and others versus Iceland, and it's about surrogacy. Actually, two women had a child by gestational surrogacy in California. None of them were genetically related to the child because donation of the gamete was used instead of their genetic material. And they moved back to the Iceland. Their parenthood was not recognized by the Icelandic authorities, despite the fact that they had birth certificate from California. But the child was entrusted to their joint foster care. And the court assessed the situation and said, okay, well, there is no violation of any article of the convention, because your link to the child was not recognized, but you were enabled to take care for a child. And foster care, from the perspective of the court, is just enough in such case that there is a genetic link and mainly also sort of a legal uncertainty created by the applicants who before that sort of know that Iceland would probably not recognize that, because according to national law, surrogacy was not allowed, and it was sort of clear that they will probably face some difficulties. So it is sort of similar to Paradiso and Campanelli versus Italy case, but in that case, the national authorities took different approach and allowed the applicants to take at least to take a care for the child compared to that case. So again, there is probably no big surprise that in case like this, the court found no violation, if previously in case Paradiso and Campanelli against Italy, there was also no violation, despite the fact that the national authorities definitely gravely interfered with the lives of the applicants and the child in that Italian case. So that's it. Thank you very much for your attention. If there are any questions or comments to those cases I have commented, you are welcome to speak right now. Or if there are any other questions or comments to previous speakers, feel free to ask. And well, if not, I guess I can thank you all for. Okay, Zdenka, please. We cannot hear you. Give me a second. Please try to turn your mic on. We cannot hear you.
Yes.
Yeah, now we can hear you.
Thank you very much. I would like to say thank you to all of you. Really, thank you very much. And I have one comment regarding the last case connected with Iceland. So I'm quite surprised that the child wasn't removed from the attended parents, like it happened in the case in Italy. When you mentioned the case Paradiso Campanelli. And my question is, perhaps you know, what about the state citizenship? Did the child receive state citizenship? And I think later on, perhaps the foster parents could adopt a child. That I think it's a new attitude to this problem. There's some movement. Yeah. So if there is no genetic connection, adoption should be available, but after some time, perhaps. So perhaps it was the reason. Yeah.
Great. Thank you for that question. Well, the child didn't get citizenship just based on the fact that from the perspective of Icelandic authorities, the mother was US citizen and father was unknown, so there was no possibility how to have Icelandic citizenship at the moment of birth or later on. But the judgment didn't mention that, but I guess as well as you that later on they will be probably able to adopt a child. I'm not sure whether joint adoption by same-sex parents is possible in Iceland. So that's something I'm not sure about, but at least one of them probably would be able to adopt the child later on. Yeah. And well, and maybe another comment. Well, in comparison to that Paradiso and Campanelli case, well, I guess that the European Court, it was a surprise for me as well that they didn't remove the child from their care. But that was a nice surprise, I would say, because the court, European Court of Human Rights clearly stated that this is sort of on national government. If they will allow them to take care for the child they cared before, like there is some link, then it is possible as well as a removal if the state authorities and the state law forbid the surrogacy. So, yeah.
I just wanted to add that same-sex adoption and in vitro fertilization is allowed in Iceland since 2006.
Okay.
So it's one of the first countries in the world that recognizes the same rights of same-sex couples when it comes to children and adoption and other rights. So yeah, and
okay,
also
great.
Yeah, thank you so much
thank
for
you very
all the
much.
presentations. It has been amazing. So thank you. It was really a great experience to listen to you again. So thank you so much.
Thank you. Thank you for your comment and also for everything. Okay, so are there any other questions from the other participants? If no, thank you all for your participation. Thank you. My special thanks goes to the speakers for their presentations, and I hope that we will see soon in person. So see you later. Bye bye.
See you next time. Bye bye. Thank you.
Bye. Have a nice day.